Good evening, everybody, and thank you for joining us tonight for this live Tenant Farmers Association webinar. We are delighted to welcome leading agricultural and property lawyer Catherine Taskis KC, barrister at Falcon Chambers in London, as our guest speaker this evening, and we'll be hearing from her in a few moments' time, because you want to hear more from her than you will want to hear from me. But I'm George Dunn. I'm the Chief Executive of the Tenant Farmers Association, and I am delighted to say that we are sponsored tonight by Roythorns Solicitors, and Roythorns are a national firm based in our rural areas. They are steeped in agriculture. They've got 90 years experience advising landowners and tenant farmers, and their lawyers are very active in policy forums and policy discussions, so they also get the bigger picture. So whether it's about a succession application under the 1986 Agricultural Holdings Act, or a new farm business tenancy, or a dispute with your landlord, or a shared farming agreement, or even a collaborative natural capital agreement, Roythorns is there to advise and assist. Now, if you miss any of tonight's webinar, or you want to go back and re-watch this at a later time, don't worry, it will be recorded, and once we've done a little bit of editing, it'll be available on the TFA's YouTube channel. And to find our YouTube channel, it's really easy. Just look for @Tenant Farmers within YouTube, and it will take you there. So the TFA video library features all of our past virtual events and knowledge share teach-ins and key news updates. And we certainly would encourage you to go and have a look and see what's there, and subscribe to the channel so you can be notified when we put up some new material. So moving on to tonight's webinar, and one of the motivations for holding this webinar was an experience that I had with one of our members, who very sadly found himself entrapped in a situation where he had significantly gone beyond the terms of his tenancy, having been encouraged to do so by his landlord. However, neither he nor his landlord had thought it necessary to draw up specific documentation to underpin the activities, which wasn't a problem until that particular landlord decided to sell their estate. Now, whilst the incoming landlord bided their time for a few years, the tenant eventually faced a barrage of documentation and notices to remedy from the landlord in respect of those alleged breaches. And to cut a very long story short, the member ended up losing the security of their Agricultural Holdings Act tenancy, had to accept a rather less secure farm business tenancy at, as you can imagine, a considerably higher rent than they were paying previously. And his words to me, which still ring in my ears, were not to let any other tenant farmer fall into the same trap. So this evening's webinar is part of my promise that I made to him that we would seek to do that. So tonight we will hear, as I said, from our guest speaker, Catherine Taskis KC, a little bit about Catherine. She joined Falcon Chambers in 1997 and took Silk in 2021. She covers all aspects of property and landlord-tenant litigation, with a particular emphasis on agriculture, including agricultural holdings, partnerships, partnership disputes. And in the last few years, she has increasingly been involved in the evolving field of natural capital and green land use in the context of land ownership. So we might have her back to talk about that at some stage. Catherine is a deputy district judge, a fellow of the Chartered Institute of Arbitrators, and serves on the council of the Agricultural Law Association. She's a joint editor of the 16th edition of Muir, Watt and Moss, one of the standard texts for agricultural holdings, and a contributing author to Atkins Court Forms Volume 4 for agricultural land. And if you go onto the Falcon Chambers website, you'll see a raft of cases which he has been involved in, and a host of endorsements, including the following one, which I thought was quite nice. It says this: Catherine is a very solid silk. She's all over her brief, and the detail and remains a strong commercial solution focus. So I think we're very fortunate to have Catherine here with us tonight, and I'll hand over to her now so that she can talk to us for the next 15 to 20 minutes, after which time we will have a interactive Q&A. So Catherine, we're so grateful for your time and expertise, and I'm delighted to hand over to you to give us your presentation. And as you do that, if you do have any questions tonight, please put them in the Q&A box at the bottom of your screen rather than the chat box, and we'll try and pick those up after I've gone through some questions that we've had in advance. So Catherine, over to you.
Thank you very much, George. Thank you for that very kind introduction. It's a very great pleasure to be here tonight and to talk through some points on this very interesting and, as you've mentioned, often very contentious subject. I should just add, following on from your introduction, that the other thing you can see on the website, should you go to the Falcon Chambers website, is a photograph of me taken probably nearer to 1997 when I started practice than presently. So it may not immediately be reconcilable with who you see on your screen today. But anyway, thank you. Now, I'm going to start, as George says, with just a bit of a short sort of presentation on the questions, some of the issues which arise in relation to breaches of tenancy agreement. And I'm going to start at a point which I'm sure everybody appreciates at the very sort of entry level point. A breach of tenancy by a tenant can entitle a landlord of an agricultural tenancy. And I should say at this point, I'm talking about the 1986 Act and tenancies of agricultural holdings. I will touch at the end, if we have time, or in the questions, if anyone has specific ones, on the 1995 Act, but that's much more straightforward in terms of the protection and the processes it covers, and so doesn't usually give rise to much litigation. So in the 1986 Act, a breach of tenancy can entitle a landlord to give a tenant notice to quit, to terminate the tenancy agreement. And there are two specific cases in Schedule 3 of the 1986 Act which may be relied upon in circumstances of a breach of tenancy, Case D and Case E. And any notice given must specify, first of all, which case the landlord is relying upon, and obviously then for the notice to be valid, the requirements of whichever case is specified must be met. So the starting point is going to be a consideration of which case applies in what particular circumstances. Now, I think there should be some slides, and at this point, slide 2, the second one, should show you the terms of Case D of the Schedule 3 of the 1986 Act. And that applies to a breach by the tenant by way of non-payment of rent or other remediable breaches. And Case E, by contrast, applies to what the Act calls irremediable breaches. Now, just going on now to slide 3, please. There are different procedures under the two cases, and just in very broad terms, if the relevant breach falls under Case D, if it's a remediable breach, then any notice to quit served by a landlord must be preceded by a preliminary notice requiring the tenant either to pay unpaid rent, if that's a breach which is relied upon, or to remedy any breach within a reasonable period. And the right to serve a notice to quit under Case D only arises if that preliminary notice is not complied with. In other words, if the rent isn't paid or if the breach isn't remedied. Both notices, either Case D or Case E notices to quit, can be challenged by a tenant by a demand for arbitration. And the tenant can serve a demand for arbitration saying that he contests the reasons stated. In other words, he says he's not in breach in the manner which is alleged, and asks the arbitrator to determine that dispute. And that's something I'll come back to maybe at the end of my slot. So the first question I want to look at in a bit more detail is the question of whether a breach is remediable or irremediable. therefore which is the appropriate notice. In lots of ways, of course, that's in the first instance the landlord's problem, because it's the landlord who has to specify and serve the correct notice. But any tenant receiving a case D or a case E notice will also want to know whether the landlord's got it right, and if he hasn't, whether there is a ground to challenge the notice on the basis that it's the wrong one. So the applicable principles here in deciding whether a notice is remediable or irremediable are the same that are found in other legal contexts, in particular in the context of the forfeiture of a lease, not just an agricultural lease, but any sort of lease. And the test that is applied broadly can be stated in these terms. I'm on slide 4 now, if that can be moved on to, and it should set out the test. And the test is whether the harm that has been done to the landlord by the breach is, for practical purposes, capable of being retrieved within a reasonable time. If within that time the landlord can be put back in the position he would have been in if the breach had not been committed, then the breach is remediable. If this cannot be done, either within a reasonable time or at all, then the breach is not remediable. And that was the summary of the test in a case called Savva and Hussain. Now, it's been said in other authorities, and I believe in that one, that the proper approach to that question should be practical rather than technical. Can the landlord be put back in the position as if the breach has not been committed? And on that basis, it would seem that many breaches might not be capable of remedy, because once they've been committed, the landlord is always going to be, or it's often going to be, in a different position than he would have been in had the breach not been committed. And there's a particularly good quote by a judge from the decision in Savva and Hussain, which goes, "The moving finger writes and cannot be recalled." In other words, once something is done or not done, then it's very difficult for technically to get back from that position. However, it seems that the courts have to consider that that is too technical, and that in fact a breach will be capable of remedy if the mischief caused by the breach can be removed. So the test really is one of effect. Is the landlord affected? How is the landlord affected, if at all, by the breach? And can he be restored to? Can the mischief that's caused him be removed? On that basis, the great majority of breaches should be capable of remedy, and that's generally how the courts and arbitrators have treated them. Most breaches of tenancy are considered to be remediable. And that includes, for example, a covenant to do something by a certain time. So if a tenant covenants to do some repairs or to some construction works within a certain time, that's a breach. A failure to comply with that covenant is a breach that's considered remediable, despite the fact that that time has passed. So the works can be done later, even though, and that will be a remediable breach, even though strictly speaking, the landlord hasn't been put back in the position which he was. That's moving finger again. I suppose it might be different if the requirement to do something within a certain time had particular consequences which could not be undone subsequently. So one example of that might be, for example, a covenant to report something which gives rise to an insurance claim, if the effect of the failure to report has been, for example, to cause the insurance claim to be refused. So even though if the report wasn't made to the landlord by a certain time, which caused the insurance claim to fail, then a later report to the landlord is obviously of no good. The landlord can't be put back in a position as if the report had been made at the right time. So that's likely to be considered, or at least arguably would be considered, an irremediable breach. What other irremediable breaches might there be? It's now clear as a matter of law that the breach of a covenant against carrying out alterations without consent is remediable, so not irremediable. For a long time, it was thought that if you did something without consent, then that was irremediable, because once it's done, and you either have consent or you don't. But that position has now changed, and it's clear that the question will be whether the mischief can be remedied. If it can be done, albeit late, then that's remediable. in the context of forfeiture, a breach of user covenant will be remediable if it causes harm to the landlord because some sort of stigma attaches to the property. In the case of use of property as a brothel, for example. Now, that's something which is not likely to arise in the agricultural context, but it's worth sort of flagging as because it sort of clarifies the nature of what an irremediable breach might be. Perhaps rather closer to home, I would suggest that the breach of a covenant not to cut timber might be considered irremediable, because that is not something arguably which could be undone. Now, the obvious breach which is considered irremediable and which is perhaps of most interest for present purposes is a breach by the assignment or subletting of a tenancy in breach of a term prohibiting any assignment or subletting. That's been held by the courts to be an irremediable breach, so one which justifies a case E rather than a case D notice. And that's based on the proposal that sort of breach involves the creation or transfer of an interest, and that even if that interest is subsequently given up or assigned back to the original assignee, the fact of its creation or the fact of its transfer cannot be undone. Now, that you might think can be criticised as overly technical in just the same way as other what used to be considered irremediable breaches might have been, but that is the subject of Court of Appeal authority, and so at present that's the way that the law stands. A subletting or assignment in breach of covenant will be considered an irremediable breach. There has been a particular limitation imposed on that principle, which is that it will only apply if the assignment or subletting transfers or creates a legal interest. So if there has been, for example, the grant of a license rather than the grant of a subtenancy, a license doesn't create a legal interest, so that will not be an irremediable breach. It might still be a breach of tenancy, but it won't be irremediable. It will be a remediable breach for the purpose of case B. I'm afraid this general area is pretty technical, and it will very much depend upon the factual circumstances, a consideration of the nature of the breach, the nature of the covenant which has been breached, and the consequences of that breach, in particular the impact of the breach on the landlord. So moving on, because I'm conscious that time is passing, if we just look at slide 5, if the breach is irremediable, then case E applies. The landlord may serve a case E notice to quit, but we can see from the terms of case E that it's not just the breach that a landlord has to prove to validate a case E notice. There are other requirements as well. The first of those is that the term breach must not be inconsistent with the tenant's responsibilities to farm in accordance with the requirements of good husbandry. That's not usually a live issue. I don't think it's an issue I've ever come across in litigation, so that's unlikely to be a problem. But more importantly is the requirement of case E as to material prejudice. The breach must at the date of the notice to quit have caused material prejudice to the interest of the landlord in the holding. And that requirement operates to safeguard a tenant's interest because it prevents the landlord from terminating an agricultural tenancy for a minor breach which doesn't have any such prejudicial effect. So the obvious question arises, what is material prejudice? The most obvious prejudice which might be caused by a breach of tenancy is damage to the value of the landlord's reversion. And if it can be shown that that is the consequence of the breach, then that's likely to satisfy the requirement of case E. However, there's no obvious reason why other types of prejudice could not also be relied upon by a landlord, potentially damage or deterioration to the land itself, or more general financial detriment. There is at present no useful authority on exactly what might constitute the material prejudice in general terms. Just a quick point here, it must be material, the prejudice which the landlord alleges to have been caused. That means appreciable, more than minor prejudice, not necessarily substantial. It's again, it's often difficult to see, or it appears very technical, that the distinction as to what might be material and what might not be. In each case, it will depend, again, on looking at the particular consequences of the breach and how that's impacted the landlord who served the notice. So in the context of a breach of covenant against assignment or subletting, which is probably the most frequent cause of a KC notice being served, it appears to be the case that there is no automatic prejudice to the landlord from the creation of a subtenancy. That is the subject of authority. And the reason that it's been held not to constitute material prejudice is because, in effect, the landlord isn't stuck with the subtenant. The landlord isn't forced into a relationship with a tenant that he hasn't chosen. And that's because a subtenant has no security of tenure against the superior landlord, the tenant's landlord. And so if the tenancy terminates, the subtenancy will fall with it. So a landlord who's relying on a KC notice has to look for something more than simply the fact of the creation of a unwanted subtenancy to make good the requirement to show material prejudice. And it's, again, a moot point. There's no authority on the position, but it may well be possible for a landlord to argue that financial prejudice might be caused to him from an unauthorised subletting. The landlord might want to argue, for example, that he has been deprived of the ability to negotiate a financial benefit from any proposed subletting because he hasn't been asked for his permission and because the subletting hasn't been authorised. So that's one argument that might be made by a landlord who serves a KC notice on the basis of a unauthorised subletting. I suppose another scenario where a landlord might be able to say that he has had material prejudice caused to him as a result of an unauthorised subletting is if the subletting itself acquires some statutory protection, which means that it wouldn't automatically fall away if the tenancy itself determined, because in those circumstances, the landlord would effectively be stuck with a subtenant that he has not authorised. And that might arise, for example, if the subtenant is conducting a business from the premises, which gives him or enables him to claim the protection, the statutory protection to business tenants under the 1954 Act. And if that's the case, if the subtenant can claim that protection, which means the landlord is obliged to enter effectively a direct relationship with a subtenant, then that arguably might be material prejudice to validate a KC notice. So lots of potential issues there surrounding the question of breach of covenant for assignment and subletting. Now I'm going to touch now on KC procedure, and I should be on slide 7, I think. If I'm counting my slides correctly. I've already commented on the point that the landlord must serve the correct notice. A case D notice must be preceded by a notice to remedy. No preliminary notice is required under case E. The only procedure to challenge a notice to quit of either sort is by a notice served by the tenant requiring arbitration. And that right is given by the Agricultural Holdings Arbitration on Notices Order 1987. The tenant must serve a notice challenging a notice to quit and requiring arbitration within a very strict time limit. It must be served within 1 month after service of the notice to quit. As I say, that's a very strict time limit. If no notice is served, or if no notice is served within that time limit, then the tenant loses the right to challenge the reasons stated in the notice to quit, even if they are ill-founded and can be shown to be ill-founded. So it's critical that a tenant who's served with a notice to quit under either case D or case E takes steps within that strict time period to take advice if necessary and to serve a counter notice demanding arbitration. I should add that if no notice requiring arbitration is served, it might still be possible for challenge to be made to any notice to quit outside the 1986 Act. So, for example, if it was served on the wrong person or identifies the wrong person, or if something was wrong in the form of notice. But that's a much more narrow category of challenge, and what the tenant would be unable to do if a notice requiring arbitration isn't served is to challenge the reasons stated in the notice. So that's why serving a counter notice is so important. If a counter notice is served, then there's another time limit to be aware of, and that's the time limit for the appointment of an arbitrator to conduct the arbitration. That time limit is 3 months after the date of service of the notice requiring arbitration. And again, that's a strict time limit. If the arbitrator is not appointed, either by agreement or by an application to one of the statutory bodies who will appoint an arbitrator in the absence of an agreement, then again, the tenant loses the right to challenge the reasons stated in the notice. So a tenant who's been served with a notice to quit and who has served a notice challenging, a counter notice challenging that notice to quit, can't sit back, because he has to make sure that 3 months further down the line, there is an arbitrator appointed. And as I say, if the landlord won't agree to that appointment, or the parties are unable to agree the identity of an arbitrator, then that means an application to ask for an arbitrator to be appointed in default. One other point to flag here, when we're talking about time limits, it's possible for a landlord who serves a case e-notice to draft that notice to take effect in the alternative as what the 1986 Act calls an ordinary notice. In other words, one that doesn't operate within Schedule 3 in the special cases, but is one where the landlord has to seek the consent of the first tier tribunal or the agricultural land tribunal to the operation of the notice on one of some different statutory grounds. So a landlord who wants to complain or take action on the basis of a breach of covenant, but also wants to pursue an alternative route to recovering the possession from the tenant on the basis of one of the statutory grounds to which a tribunal can consent, can, if he wishes to, serve a single notice which will enable him to pursue both grounds. And if he does that, then what the 1986 Act provides is that the arbitration process must be exhausted first, if that's pursued. If the tenant is unsuccessful in challenging the reasons stated in the case D or the case E notice, then the notice takes effect. If the tenant is successful, so if the landlord can't prove the grounds in case D or the grounds in case E, then a landlord who served one of these double-sided notices then has an opportunity to seek the consent of the tribunal to the termination of the tenancy on such ground as he may specify. And of course, that an application for the consent of the tribunal is something else which can be challenged by a tenant, but again, subject to a time limit. So if there is this double-sided notice, the tenant who has, if you like, got through the case E, case D process, again, needs to be alert to the fact that he may have another time limit to meet to serve a counter notice to this, the second side of the notice, if you like, and that's another time limit that he mustn't let slip. That doesn't happen very often. It's more usual, I think, if a landlord does have alternative routes to possession, for a landlord to try one first, perhaps, and then wait and see how that goes before he pursues another. But it's something to be aware of. Now, very quickly, just on the Agricultural Tenancies Act 1995, farm business tenancies, a completely separate regime, a much more straightforward regime, in the sense that there is much less statutory process involved. There is no specific regime in the 1995 Act to terminate a farm business tenancy for breach of covenant, so no equivalent to any of the cases in the 1986 Act. But the thing to be aware of a farm business tenancy is that it may well contain a forfeiture clause, which will enable a landlord to seek to terminate the tenancy by way of forfeiture in the event of a tenant's breach of covenant. And that will operate in the same way as any other lease. There's no special provision or no special rules for a agricultural farm business tenancy. Forfeiture will operate as it usually does. A landlord will need to give a preliminary notice if the breach is anything other than non-payment of rent. the tenant must be given an opportunity, a reasonable period to remedy the breach. And of course, the key thing to remember with a forfeiture, a notice seeking forfeiture and a forfeiture claim, is that the tenant has an opportunity to apply to the court for relief from forfeiture. That is likely to require him to remedy the breach or to compensate the landlord for the breach. But a tenant who does so has a good chance of seeing off the forfeiture and avoiding the determination of his farm business tenancy. And I think I've more than filled my 15-minute slot, so I think it's probably time to move to questions, George.
Wow, Catherine, what a tour de force. Thanks so much for explaining that so fully and so understandably. I'm sure there will be a lot of people who will be watching this back just to squeeze every last bit of wisdom and knowledge from what you said there. So thanks for that. Yeah, so just a few questions. There's a few questions come in on the Q&A as well, which we'll get to. But if anybody else has got any questions they want to put into the Q&A, please do so, and we'll get to as many as we can before we close tonight's webinar. But maybe I can tease you out a little bit, Catherine, on some of the defenses that tenants may seek to use in the event that they do face action from the landlord for an alleged breach. And there's three in particular that it would be really helpful to get your view on. And the first one of those is what's called, I believe, derogation from grant. And this is where maybe in advance of a letting, the landlord and the tenant have discussed a particular type of activity on the holding, and where it's clearly intended that the holding should be let for that purpose. But for whatever reason, the written agreement doesn't follow what they had agreed in advance of the letting being put in place, and the tenant has cracked on as he thought he could. And the landlord has now attempted to cry foul, and the tenant said, well, hang on a minute, this was the reason why you let me the place in the first place, so what isn't that a derogation from grant? The second one, which is similar, is the issue of waiver. So that's where maybe the tenancy agreement itself doesn't give the necessary consent, or they haven't entered into a separate memorandum for that consent, but either the landlord has tacitly or has deliberately allowed an activity to carry on, which is technically in breach of the agreement, and then seeks to try and bring that to a conclusion. And whether the tenant can claim, well, the landlord's waived his right to do that because of the way he's acted. And the third one, again, connected, and I'm sorry to throw three complicated questions at you all at once, but I think they are so interconnected that it's important, is what we hear is the doctrine of Estoppel. Which, as I understand it, is where someone has given a commitment to do something or to grant a consent for something, which the tenant then maybe acts upon on the basis of that promise or that commitment given, but the landlord never follows through with that and then seeks to try and stop the tenant from doing what they're doing. And the tenant says, hang on a minute, you promised you'd do this. And you haven't, and I relied upon it to my detriment, so surely I can carry on with what I'm doing. So derogation from grant, waiver, and estoppel, three legal concepts that hopefully you'll unpack for us, Kat.
Yes, let me see what I can do with those. I'll take them separately. Derogation from grant, I think, is slightly different to the other two, and I'm not sure would be the most helpful. Well, it's all going to be very subject specific, but I think it is slightly different from the other two for this reason. The principle of non-derogation from grant basically says that a landlord who has granted a particular benefit or a particular bundle of rights to his tenant cannot do anything which would in effect deprive the tenant of the enjoyment of those rights. So it's the principle which says you can't give with one hand and take away with another. And it's most often helpful in circumstances where, for example, a lease contains clauses which entitles or retains rights to the landlord to go onto the land or to carry out activities on the land. And then there's a dispute between the landlord and tenant about the fact that those activities are interfering with the tenant's use of the land. And in those circumstances, the principle of non-derogation from grant might be helpful to prevent the landlord from doing anything which effectively is stopping the tenant using the land for the purpose for which it was let to him. So it sort of operates, if that makes sense, it operates within the context of the lease. It says this is the bundle of rights that the tenant has been given by the lease, and the landlord can't go back on that and can't detract from those. So it probably won't be at its most helpful in the sort of first set of circumstances that we're thinking about, which is where the landlord and the tenant might have discussed a certain activity or the possibility of certain activity, but actually that's not covered by the lease. I think it's unlikely to help the landlord there, because ultimately the parties are bound by the terms of the lease that was entered into. Obviously, there are exceptions to that. There might be an argument about the fact that the lease doesn't properly record the parties' agreement, but your starting point there will be the lease. Now, waiver and estoppel, by contrast, might be slightly more helpful, because those are both principles which operate, if you like, outside the terms of the written agreement, so outside the terms of the lease. So the argument of waiver may arise where what the tenant is doing, in your example, George, is strictly outside the terms of the lease. And so he's not authorised to do it, but it's something that the landlord has known about, quite possibly even discussed with the tenant, and may well have acquiesced in for a period of time. So he's seen this happening. He understands what the tenant is doing and that it's outside the terms of the tenancy agreement, but he hasn't said anything. He's stood by and let the tenant continue. And so if subsequently the landlord tries to turn around and say, well, actually, I'm going to serve a notice based upon what you're doing because it's outside the terms of the lease. In those circumstances, the tenant may be able to say, you can't do that. You've waived your right to enforce a breach of enforce against me for breach of covenant, because you have known about it and you have elected not to do that. So really, waiver arises there. It sort of it almost creates an inference of consent. So in those circumstances, if you can infer from what the landlord has done, i.e., known what's going on and not done anything about it, that effectively he's consented to those activities or that action, then you can possibly make an argument that he's waived his right to object to that. It will all be very circumstance specific. The thing to note with that is that if that operates in relation to a particular breach of covenant, so let's say the tenant erected a building which was unauthorized, but the landlord knew he was erecting it and let him do it, that might prevent the landlord from taking enforcement action in relation to that particular building, but it wouldn't necessarily entitle the tenant to go on and put up another building, because it would be specific to that particular action. Now, Estoppel operates in similar circumstances, and in a similar sort of way. It effectively prevents a landlord from enforcing the strict terms of the written agreement if the circumstances are such that he shouldn't be able to. And there's sort of a threefold test for whether there has been whether an estoppel might arise. And that is if there has been some sort of representation or statement or promise by the landlord that the tenant could do something or carry on some activity upon which the tenant has relied, and upon which, this is a third thing then, upon which the tenant has acted to his detriment. So again, using the example of the construction of a building in breach of covenant, if a tenant is able to, that might strictly be against the terms of the tenancy agreement, but if a tenant could show that the landlord promised him that he'd be able to do that, and that the tenant relied on that promise and invested a considerable amount of money to his detriment in putting up that building, then that might give rise to an argument of estoppel, which would prevent the landlord from enforcing his strict right to object to that building. So that you can see that there's possibly some sort of overlap there between waiver and estoppel, depending upon exactly what has happened, what discussions have been had, what the landlord knows, etc. So those are certainly possible defences for either a one-off activity like putting up a building, or the continuation of some user of the land, for example, which the landlord has been aware of and that the tenant has been carrying on.
Great, thanks for that, Catherine. Very, very, very clear, as I would expect. So going back to case E and the fact that it's immediately a notice to quit on the basis of a breach that the tenant has alleged to have committed.
Yeah.
Given the high stakes for the tenant in those circumstances, even where the tenant strongly believes they are on strong grounds for defending against that notice, having followed the procedures, obviously, that you've referred to, how would you advise a client to proceed practically in those circumstances? What should they be doing?
Yes, it's tricky, isn't it? Not least because, of course, the basis of a KC notice, an irremediable breach, suggests that there's actually nothing that the tenant can do. But as we've heard, given the sort of slightly nebulous nature of what is an irremediable breach, there may well be things that the tenant, despite how well-founded he thinks his case is, might be able to do to protect his position. And I would suggest that really the thing to look to is, well, even if a tenant thinks he has a strong ground to say this wasn't a breach, or this wasn't an irremediable breach, it might be that he would be well advised to try and unpick some of the things that the landlord has objected to, because if nothing else, that will potentially protect him on the question of the material prejudice argument. Because if the landlord pursues the KC notice and has to show material prejudice, and the tenant can say, well, actually, okay, I disagree with you, but if you agree that this is a breach of my tenancy agreement, look, I've undone it. Any harm that was done to you has been remedied. Then that will put him in a good position, or potentially in a better position when it comes to arguing about material prejudice. Because if the breach has been put right, then it would be much more difficult for a landlord to show that he has suffered material prejudice as a result of that breach. And of course, if he can't show material prejudice, then he can't rely on the notice.
Right, thanks, Catherine. Another common occurrence that we come up against within the TFA quite regularly is where you have a tenancy agreement which restricts the tenant from subletting, parting with possession, or even sharing possession of the holding. Would that preclude them from farming through the auspices of a company or in a partnership?
Well, there's $1 million question. And you probably won't be surprised to learn there's no obvious answer to that. There's all sorts of types of clause in a tenancy agreement. That will be your starting point. What exactly does the clause say? What does it prohibit? Because some of them only prohibit subletting, some of them prohibit subletting or parting with possession, some of them prohibit both of those and sharing occupation. And each of those three terms, subletting, parting with possession, sharing occupation, all have particular legal meanings. So a subletting is the most obvious. It means the grant of an exclusive interest, a tenancy interest, to a third party who holds from the tenant. Whereas parting with possession and sharing occupation are generally lesser sort of interests. So you can part with possession to someone even if they're not a subtenant. You can share occupation with someone even though they don't have a subtenancy. So your starting point will be to look at exactly what's prohibited, and then the next stage will be to look at exactly how a partnership or a company uses the land. So how does this operate? Now, in the case of a partnership, a common situation is that there will be a landowning partner, and other partners, and that landowning partner will permit the other partners to use the land for the course of the purpose of the partnership business. Now, that could be by way of a formal tenancy granted to the partnership. And of course, if there was a covenant in the tenancy prohibiting subletting, then that would be a breach. It more often than not, of course, it isn't by way of a formal tenancy. It's an informal agreement, and it's likely to be a license, some sort of license arrangement. Strictly speaking, it's quite probable that none of the partners have really thought about it very hard. They won't have had any discussion. There will be no sort of formal analysis about the legal basis upon which the partnership is using the land. But in those circumstances, quite often a court will infer a license, a permission from the landowning partner for his other partners to use the land. And a license is not strictly a subletting, so that wouldn't be a breach of a covenant prohibiting subletting. It might constitute on the other end of the scale, it may well constitute a sharing of occupation, because the tenant has let other parties share the use of the land with him. The other partners are sharing the use of the land with the tenant partner. Parting with possession, which is somewhere in between, that's where we enter our grey area, and it will depend upon exactly what the partnership does, whether the tenant partner retains any particular rights or any particular part of the property. So no easy answer, but those are the sort of factors which would need to be looked at in any particular case. Same with the company.
Any partnership that hasn't thought about those land issues needs to think about them pretty quick. And obviously, if you're thinking of entering into a partnership, then one of the questions you need to ask your advisors is, what about how the partnership accesses the land? That's great.
Exactly. Yeah.
Okay, so a few housing-related questions for you. Now, there's a couple that have come in advance and one that's come in the Q&A. So this is it's a bit complicated, but let me try and get this one right. So we have a situation where there's an Agricultural Holdings Act tenancy, and there is a clause which allows the tenant to house farm workers in cottages on what's known as service occupancy agreements. But we know, Catherine, don't we, that there is legislation which protects agricultural workers from eviction after a period of time of occupation. I think it's 91 weeks, where they turn into assured tenants in those cottages. But given the landlord's consent to allow a service occupancy, which by dint of statute then becomes assured, would that be a breach of the AHA tenancy in terms of subletting, or would that be allowed? So is that a defense a tenant could bring in those circumstances?
I think that probably wouldn't be a breach, because the breach arises not. The breach results not directly from what the tenant has done, letting in his service occupier, but rather from the statutory intervention, if you like, on that service occupancy. So if the tenancy agreement, if I understood you right, George, if the tenancy agreement permits the grant of service occupancies, then the tenant can do that. The fact that subsequently, by the operation of statute on that service occupancy, it becomes something else, I would say arguably doesn't mean that what the tenant did in the first place constituted a breach of covenant. It seems to me there's at least, again, it's all going to depend on the terms of the tenancy, but there does seem to me to be a good argument in those circumstances to say all that the tenant is doing is what he's permitted to do. The fact that it has these consequences by virtue of how the statute works doesn't mean that he's not permitted to do that.
And therefore, perhaps strong grounds for the tenant to go to the landlord to say, well, let's just grant a short show whole tenancy then, because otherwise you're going to end up with an occupier that you can't get rid of. Yeah.
Well, exactly. From a pragmatic point of view, you're right. A landlord would be well served to take a sensible approach to that, as you say, and have a subtenant that can be dealt with more easily. Yeah.
Okay, so another old chestnut from a housing perspective, which has come in advance. So this is a situation, it's another AHA tenancy, and the tenancy states that the tenant must reside in the farmhouse. But this tenant has bought a house that he now wishes to retire to and wishes to allow his son to live in the farmhouse. Can they do that?
On the face of it, no. Unfortunately, I can absolutely see that that's a situation which arises quite commonly, while the father is still the tenant, but perhaps not. Yeah, doesn't need the large farmhouse anymore. His children might do, or his son might do. But on the face of it, unfortunately, if there is, again, it will be clause specific. But if there is a clause requiring the tenant, who is presumably named and identified in the tenancy agreement, to reside in the farmhouse, then if he permits somebody else, his son or anybody else, to reside in the farmhouse instead, then that is potentially a breach of covenant. I mean, again, it would be good to think that that's the sort of thing that could be addressed sensibly with a landlord, but a tenant would have to tread a bit carefully, because on the face of it, that might give rise to.
So our members do get themselves into some pickles here. So here's one that has been put to us by James tonight. So James has got a farm worker on a service occupancy agreement, and the farm worker has, unbeknown to James, started a turkey rearing business, but the business is carried out on a holding other than James's, but he uses the home address of the service occupancy as the business address, and he's concerned that the landlord might say that he's allowed subletting to be carried out because of the use of the domestic address as his business address. Is that something that James is at risk of? If the business is registered at the cottage.
Okay. I mean, if I don't think that fact alone should constitute a breach. If the tenancy agreement permits occupation by a farm worker on a service occupancy, and if this worker is working for the tenant, and therefore can properly be said to be occupying on a service occupancy basis, then that seems to me it ought to be compliant. Notwithstanding, by the sounds of it, if he's also working elsewhere and using this address for that purpose. I think what would have to be looked at is whether this particular worker satisfies the necessary conditions for what is permitted. You know, he obviously, if what is permitted is a subletting to a service occupancy to a farm worker, if in fact he's not really, for practical purposes, working on the farm at all because of his business elsewhere, then that might be problematic. But if he is working on the farm, the fact that he has a sideline, even if he uses his home address for the purpose of that sideline, shouldn't necessarily itself give rise to a breach, I think.
Okay, so here's a couple of other scenarios from Christine and someone who doesn't give their name in their question, but very similar circumstances. So Christine says, if we allowed someone to use a room in a building on the farm for a joinery activity, we let them use it free of charge, is that classed as a sublet? And the anonymous questioner has said, if we allow someone to store some equipment without charge in a building, would that be a breach of contract if there was no subletting or sharing possession or whatever?
Okay. Well, taking those in turn, the joinery and would that be a sublet? As I say, there are various types of alienation or which may be prohibited. Subletting very specifically arises where there's been a grant of a tenancy, and the key factor in granting a tenancy to someone is giving that person exclusive possession of the premises or part of the premises. The payment of rent is another indicator that there's been the grant of a subtenancy, but not a necessary indicator. So if you've been given exclusive possession of a room or whatever it might be, a barn, even if you're not paying rent for it, you could still be a subtenant. So in this case, the question is not so much that the room has been given for these joinery purposes free. The question is the joiner, if the person has exclusive possession of whatever area he's been given, and can he exclude the tenant from it? If he's simply been given a workbench, for example, at one end of a barn, into which the tenant comes and goes for other purposes, his own purposes, then it seems to me that it's unlikely that the person using it for joinery could say he's got exclusive possession, and therefore that there's been a subletting. If, on the other hand, a joiner has a sort of separate room, maybe with a lock and key that he lets himself into and out of, and that the tenant no longer goes into or uses, then there is much greater danger there that could be interpreted as the grant of a tenancy in relation to that particular area. So that was that one. Remind me the second one.
Storage was the second one, allowing someone to store equipment, yes. FOC.
I mean, again, it's really going to depend on what is prohibited under the clause in the tenancy and what is happening on the ground. So if the tenancy prohibits subletting, full stop, and all that's happened here is that there's a third party storing some things in a barn which the tenant is using, then I don't think that's likely to be problematic. If, on the other hand, the clause in the tenancy agreement is wider, so this, as well as prohibiting subletting, it prohibits parting with possession or probably more pertinently sharing occupation, then the fact that a third party is sharing the premises to store some goods, subject perhaps to a real de minimis tiny amount, then that might be more problematic. Yeah, it's all going to be very fact and degree sort of specific. It's going to need a careful look at what the tenancy says and what's happening on the ground.
Okay, so Keith asks a question, which is, would allowing someone to plant, harvest a crop of cereal or maize for a fixed payment on land which is rented under the 86 Act, which he rents, obviously Keith rents under the 86 Act, be classed as a subletting or a breach? And there's no written agreement entered into with the person growing the crop, but he's clearly been allowed to grow a crop for a fixed payment.
Again, I'm not going to give a definitive answer because it will be very fact specific. It will depend on such things. I mean, there's a sort of contract farming arrangement where both parties have a stake in the outcome of the crop. I don't know exactly what a fixed payment might be, but there's a range of possible scenarios, most of which probably wouldn't constitute a subletting. Again, the key to a subletting would be if this third party effectively acquires from the tenant all the rights in relation to that particular bit of land. So the tenant can't go onto it, can't use it, can be excluded by the third party. I mean, potentially planting a crop, I suppose, does take it out of the tenant's use. So it might be said that the party who's been allowed in to plant the crop does have exclusive use of the particular area. Yeah, I mean, I'm afraid that other than talking sort of going on in more general terms, all I can say is it's going to depend upon the particular arrangement made and the period of time which the land is used for, whether this is a regular occurrence or not, or a one-off. It would all depend on the particular circumstances.
Okay, you'll be glad to know, Catherine, I'm going to make this the last question, but it's clearly from someone who knows what they're talking about, and it relates to FBT. So it's we've been talking about 86 Act agreements. So this is from Gemma, who says, and you might need to explain some of the terms that she uses in her question, but she says if an FBT is void as a deed and is therefore an equitable lease, can there be grounds to suggest that it is not binding as an equitable lease because specific performance would not be granted, so that the tenant can potentially get out of a full put and keep repairing FBT, that's on repairs, when they have taken over an already dilapidated traditional farm buildings. So I think we need to explain what void as a deed means, what equitable lease means, and what specific performance means before you answer those questions.
How long have I got?
I know, yeah, and you've only got a couple of minutes.
Right. I'll see what I can do. I mean, what's being referred to here is the situation where certain types of lease, and it's normally leases granted for a certain period of time, have to be granted formally by a deed, which is not just a written agreement, but a written agreement which is signed and sealed. And in circumstances where the parties intend to enter a particular agreement which requires that degree of formality to be valid, but the formalities aren't complied with, so it's void, it's ineffective as a deed, then sometimes the law will step in and say, well, you haven't got the formal interest which was meant to be granted by deed because you didn't tick all the relevant boxes, but you've got sort of the equivalent thing in equity. So equity is sort of a legal principle which says, well, you haven't complied with the legal formalities, but we're going to treat you in the same way because justice and good conscience requires so. So here, I think the scenario must be that the parties intended to enter a certain type of lease, which for whatever reason didn't take effect formally. And so the argument is, well, it would have taken effect. The parties should be treated as having entered this agreement, even if they got the formalities wrong. And by the looks of the question, I'm just looking at it on the Q&A. The question arises because the tenant doesn't want to be bound by it, by the looks of it, because he doesn't want to have to take on the responsibilities. The answer, again, you're not going to be surprised to hear, is that it will depend upon all the circumstances. But the reason that equity intervenes where formalities haven't been complied with is because it would be unconscionable, it would be unfair to treat the parties who tried to enter an agreement as having failed simply because they haven't jumped through the right hoops. So if this is a case where the parties have operated, even though they got the formalities wrong, they've treated each other, they've gone forward on the basis that this was the agreement that they have entered, then those are the circumstances where the equity would say, okay, we're going to treat you as if you did it properly. So I think in order to get out of it, the tenant would need to be in a position to say, well, look, actually, we got the formalities wrong and nobody's acted as if this was the agreement between us. We haven't paid the rent that was due under the lease. We haven't done anything else which would suggest that we're operating under the terms that we meant to agree. The converse of that, of course, is that if this is some time down the line and everybody's been acting as if this is the agreement that the parties are bound by, then it's going to be much more difficult for the tenant to turn around at that point and say, actually, the lease wasn't entered properly, so I'm not bound by it. So that's a very, very complex question, which I've tried to shoehorn into.
If I can put it in a very non-legal way, Catherine, what you're saying is the tenant can't have their cake and eat it.
I think that's a much more succinct summary, George, of what I was trying to say. Exactly right.
Excellent. Catherine, you have been Catherine, you've been so generous with your time and your expertise and your wisdom tonight. So we are gonna let you go and to say thank you so much for taking the time to be with us tonight. Those on the call tonight won't know this, but poor Catherine's got me twice this week. So she's got me tomorrow at the ALA's annual conference in London, where we're talking about the rules of tenancy succession. So I'm sorry about that, Catherine. You've got me You got me twice this week, but huge thanks for what you've done tonight, and also huge thanks to Roy Thorns again, our sponsors for tonight. And I should also say thank you to Julia Meadows, who's been behind the scenes, keeping us all technically correct and up to speed. So before we sign off for tonight, just to let you know that we will be holding another virtual event next month. It's going to be a bit different. It's going to be a panel discussion. It'll be on Wednesday, the 26th of March at 7 p.m. And the title for the event is A View from the Field, the Good, the Bad, and the Ugly of Tenant Farming. It'll feature a special panel made up of TFA members, and we're very chuffed that it will be hosted by the chief reporter from the Farmers Guardian, Rachel Brown, who I know will be known to many people on this webinar tonight. It'll be a free event. It'll include a live Q&A, so attendees will have a chance to ask questions to the panelists, and it will be broadcast via Zoom, and we anticipate that it should last an hour. So sorry we didn't get to all of the questions. I might see if I can tease Catherine to answering some of the ones we didn't get to tonight, so we can put them in a member's blog. But again, thanks to Catherine, thanks to our sponsors, Roy Thorne, thanks to you for joining. We hope you find it useful, and we'll see you again soon. Good night.